Research Associate en Policy Analyst voor het Nationaal Contactpunt in Duitsland. Please, you have the floor, Janne.
Good morning, everyone. Thank you very much for the introduction and for having me at this conference. And in my presentation, first I will start also with the perspective of the beneficiaries of protection themselves and what we in Germany know about the reasons why they intend to or actually travel to their country of origin. I will then touch upon how the authorities learn about it, how they notify each other, followed by the revocation procedure, which is the cessation procedure. We call it revocation procedure. And I will also give some insight on the consequences on the right of residence. And my presentation is based on the German Yemen study on the beneficiaries of international protection. It's also, here it says only protection because we also have national protection statuses. So, and I authored that study, and you may find it online or also some printed copies outside on the desk. So in general, beneficiaries of protection are allowed to travel abroad and are issued with a refugee travel document or a so-called convention passport. And in Germany, that document contains a note which says that document is not valid for the country of origin, which, however, does not provide legal grounds for a general administrative prohibition to travel to the country of origin. Then again, there is no notification procedure for the beneficiaries of protection themselves to notify any authorities about their intent to travel to the country of origin, which means that travels to the country of origin are not generally prohibited, but it is also not possible to get a guarantee beforehand that the protection status will not be revoked upon their return. So why do beneficiaries of protection intend to or actually travel to their country of origin? And we already have heard already a little about by Ina, but I think it's important to stress this point because also in Germany the public discourse on this matter has mainly been instrumentalized by right-wing populists mostly, who also tried to frame it and generalize it only under the umbrella of holiday travels and travels for leisure purposes, while the reality turns out to be a little more, much more complicated and complex. So among those more common individual reasons for traveling to the country of origin are deaths of family members and the organization of funerals or participation in funerals, illness of family members and the need to look after or nurse them, clarifying inheritance issues or selling property, for example, if a family member died, marriage, divorce, or participating in the marriage of family members, helping family members to flee, or supporting friends and relatives in emergency situations, but also business affairs in case someone ran or starts to run a business. Other reasons are, for example, checking the risks to actually travel to the country of origin if someone plans to re-establish him or herself permanently, go back permanently, with the family, but not wanting to risk to go with the whole family, but checking out the situation first. So that can be one reason. Another reason is homesickness and also leisure purposes. One reason which I only learned last week about, and which is not covered in our study, but which will most likely become more relevant in the near future, is children which were born by beneficiaries of protection in Germany, and the relatives who stayed in the countries of origin wanting to see them which becomes especially important in the combination with other of the mentioned reasons, such as illness. So if grandparents feel that they will not live much longer, but wanting to see their grandchildren at least once, that can put some pressure on beneficiaries of protection to actually go at least for a week or so to their country of origin. So there's no central register in Germany documenting the reasons or the number of such travels and reasons. So I may not give you any statistics on the phenomenon, but only report on the experience of the case officers and court rulings stating that all these cases exist and also reasons exist, and that the overall number from a German perspective is not so large. And while most beneficiaries of protection do not travel to the country of origin, even though most probably experience at least one of these reasons I just mentioned, some actually do. And with regard to travel routes, in most cases, they either fly to neighboring countries from Germany directly, or they go to other EU member states and fly from there, either because the flight connection is more convenient, or, as Ina already said, try to avoid being detected, as their passport will then not be checked upon their return to Germany. So in Germany, the Federal Office for Migration and Refugees is responsible for checking such travels and for the revocation procedure. However, in most cases, the federal police learns about such travels first, upon the passport control, for example, and then they notify the federal office. And as I said, if the beneficiary of protection travels via another member state, the German authorities might not learn about it, but as Ina also pointed out, in recent years there have been established on a bilateral basis notification procedures with some member states to inform if a beneficiary of protection from another member state is detected at their border, for example. In Germany itself, several authorities may learn about such travels. For example, foreigners authorities, but also labor offices and job centers. For example, in Germany, those beneficiaries of protection who receive social or asylum benefits are not allowed to stay away longer than 3 weeks. So if they do, this can be an indication for the labor office to ask, where have you been, and to detect that they have been in the country of origin. And once the Federal Office for Migration and Refugees learns about such a travel, it automatically launches an examination procedure on the case, which is a pre-step to the revocation procedure. So they send out a questionnaire to the Foreigners Office and to the security offices, asking about any additional information on that travel or additional reasons for revocation of the protection status. And if the answer contains information suggesting that there are plausible reasons for the travel and that the beneficiary of protection did not re-avail him or herself of the protection of the country of origin, then the federal office may decide not to go further with the revocation procedure, but to stop it. If, however, the inquiry does bring up any additional incriminating information, then the federal office will definitely start a revocation procedure. So the main question for the case officer of the federal office in the incident-related revocation procedure is whether the person in question has re-availed him or herself of the protection of the country of origin, as defined in the cessation clauses of the Geneva Convention, as well as in the EU Qualification Directive. And as you have heard from Ina already, in at least one member state, an automatic cessation of the procedures protection status takes place only in one member state, and this was was partly true also for Germany until mid of 2015. And this is when the EU Asylum Procedures Directive came directly effective. And with Article 45 of the Asylum Procedures Directive, it is laid down that international protection shall only lapse by law where the beneficiary of protection has unequivocally renounced his or her recognition as such. This means that the protection status can only lapse by law if the foreigner applies for German nationality, for example, or renounces the recognition status him or herself. In all other cases, an individual revocation procedure needs to take place. So when assessing grounds for revocation, where a beneficiary of protection has traveled to the country of origin, 3 fundamental criteria need to be considered. Firstly, he or she must act of his or her own free will when deciding to re-avail him or herself, which is, for example, not the case when the re-establishment in the country of origin was the result of force, threats, or fraud. Secondly, he or she must act with the intention to re-avail him or herself, which might, for example, be the case if a person accepts a job offer with a state enterprise. And the situation is quite clear, actually. And thirdly, he or she must indeed, the protection must indeed be granted by the regional or state authorities. So they must be able to actually guarantee the protection of the returnee. So in order to decide on these 3 fundamental criteria, several specific criteria are set up. These are the length and frequency of travel. So multiple travels are a stronger indication that the person actually re-avails him or herself of the protection. The occasion, so the reason, and whether there has been a moral obligation for that travel, such as a funeral. The way of entering the country is also important. For example, whether or not the state authorities were aware of the person entering the country. And the location of stay is also an indication for such. So if you may consider that the state authorities or rebel groups actually must have known of the person staying in the country but did not do anything about it, then that might be an indication that the protection is not needed anymore. So we can see already that just as in the asylum procedure, a mistake by the Federal Office for Migration and Refugees might have quite severe consequences for the person, which is why it is important to take this seriously and take particular care when assessing such a revocation. From a procedural perspective, the beneficiary of protection will be informed in writing that the Federal Office intends to revoke their protection status and because of the travel. And the beneficiary themselves then have again 1 month to respond in writing. And this is a moment where most of them consult a lawyer, and their written answer again often provides additional information on the mentioned criteria, which may underline why the person went there and how. This can be, for example, photos of the funeral or reports from a hospital where a relative is nursed and so on. So these are all additional information gathered at that point. If the information is considered as authentic and plausible, the revocation procedure might be ended. If additional information is needed, a personal interview may take place, which is not very common in Germany yet, however. And if the beneficiary of protection does not provide or not respond to the letter, the Federal Office will decide on the basis of the indication as it stands, which means, as a rule, they will revoke the protection status. Last but not least, if a protection status is revoked, the foreigners' office are then responsible for checking whether the residence permit shall be revoked as well. So it's not the Federal Office for Migration and Refugees, but the foreigners' offices. And again, several criteria are taken into consideration at that point. So either there is a right to residence which is independent of the right for asylum. For example, due to a marriage in Germany, then another residence permit may be issued. Or there are obstacles to a forced or to a return, and the removal is suspended. Or thirdly, the residence permit is also revoked and the person is obliged to leave the country, either voluntarily or also forced. And in the study, you may find additional information on all these aspects, criteria, and procedures, as well as also the specifics for beneficiaries of subsidiary protection, as well as on contacts with the authorities of the country of origin, which I did not touch in order to not to make it too complicated. And last but not least, you will find this infographic as a poster in the study, but also online, which leads you through the steps, or through the phases step by step. So if you're interested in that, please have a look. And thank you for your attention, and looking for the discussion. Thanks.